morning, people. I thought I'd make a quick video while I'm on my way to the house to try to get into caregiver mode. So I thought I'd make this video before I get all in there and get settled in and get it all popping. Because I was just thinking about, the people I've talked to on the phone, in the last few years, actually, not just recently, but throughout the years, who are dealing with child support cases, or any case really, that are, cases where where their estate is the defendant. I'm gonna say their name. For some of you don't know that your name is the name of your estate. The name on their docket is the name of your estate. I'm gonna start saying that so it can get in y'all's head, so y'all can stop thinking the name is you. But where their name is the defendant, they get in there trying to prove the plaintiff to be wrong. They're trying to prove themselves innocent. It's not your job to try to prove anything. The burden of proof is on the one who brings the case. So anytime someone brings a case against your name, it's their job to prove that what they're accusing you of doing is their job to prove that you did it. Not you try to disprove them. I was talking to a friend of mine yesterday about, how some people get in court and they talk too damn much. Trying to prove too much. If your name is the defendant, you shouldn't be in there doing all that damn talking. You shouldn't be doing all that talking. You should give them a chance to prove their case. And any attorney that's trying to speak on behalf of the one who's accusing you, they need to be under oath. Because anything they say from that, that's not under, anything they say is hearsay. They have no first-hand knowledge. So you should be objecting anytime an attorney try to speak against you anyway. I wish I'd known that back when I was fighting my child support case back in 2016. Because my son's mom wasn't doing much talking at all. It was her attorney doing all the talking. I didn't know what I know now. I wouldn't dare let an attorney try to speak to a judge on my behalf concerning a situation with me and my son's mother. I would object any damn thing they say because they have no first-hand knowledge. Unless they're willing to testify under penalty of perjury, they ain't got shit to say about the situation. And that's how everybody need to be, no matter what kind of case it is. Nobody should never let an attorney testify against you unless they're doing it under penalty of perjury. If they're not going to do it, whatever they're saying is hearsay. And you shouldn't let them get away with doing it. Back to my original point. If they have your name in there as a defendant and you sit here speaking, you're trying to put evidence on the evidence to prove you innocent. You're doing too much. You're doing too much. Especially if it's not even something, nothing, you know what I'm saying? Especially like, say a child support case, for instance. It's not even like, I see if you're dealing with some type of felony case and you have evidence to, that's gonna prove them wrong. That's gonna shut the whole case down. That's different, But when you go in there trying to explain, like say, I guess I'm mainly focused on the child support type, and custody type cases. And when you're in there trying to take your check stubs in there, trying to prove how good of a father you are, or if it's a female in this situation, how good of a mother you are, trying to show how much money you done spent on them. That ain't no damn body business. It's not the court's business how much money you spent on your baby. What you did, what you bought, all of that. You go in there, you giving them that, you creating an implied perception that is as if they have authority over how you deal with your affairs privately. They have no authority over your private affairs unless you invite them into it. And that's one of the main keys of how I shut them down the last time I fought child support. I don't go in there giving them no type of authority. They ain't their damn business what I do for my child. You know, what I do for my child, just like when me and his mom, when he was conceived, we were by ourselves. In private. In a private room by ourselves, and nobody was there. And I'd be damned if I invite anybody. I don't give a damn what kind of uniform they have on. They don't get to come in, they don't get to ask me questions about what I do for my baby. That's the kind of stance you gotta have. You don't have to be belligerent about it, but you have to get them out your business. That's like if I walk up to somebody, how much money you got in your wallet? You cuss me out on sight because you ain't got no business asking you that. It ain't my business. It's not a judge's business as to what you spend on your baby. How much, where you work at, how much money you make. What's the social security number to your estate? They didn't say what's your social security number because they act like you operating as somebody incompetent. No man or woman has a number attached to them. It's your estate that has a number assigned to it. So just get that free. They don't be telling folks you got a social, because you don't have a social. Your estate has a social. Okay, but it's not nobody's business what it is that you got going on. And you invite people in your business, they're gonna get in your business. They ask you, do you work anywhere? It ain't your business. How much money you make a month? It's not your business. You got the right to keep that quiet. That's private information. You don't have to give. You have the right to privacy, and nobody can violate that right for you to set the fuck up and keep your business to yourself. This is a right, y'all. This is the law. Nobody can make you give them anything, and they can't hold you in contempt for not giving personal information away to them. They can't do it. They don't have that kind of power. But you have to stand on that. And if you go to talk to these people like you pussy, then they're gonna treat you like pussy. That's what they're gonna do. That's just the real deal. I was talking to a buddy of mine, a couple months ago. Had a damn $120,000 settlement he was supposed to get. He serving these people, but he talking to them on the phone, and he sounds scared as hell. Talking to me scared as hell. Want me to talk to these people. Be all on three-way with these people about his money. Because he's too scared to speak up for himself. You give these people if you make them feel like they're superior to you, they're going to treat you like they're superior to you. That's how that goes, y'all. That's how that goes. My father and mother don't treat me like that. So I'll be damned if any man or woman standing there walking around gonna say and make me feel like I gotta be inferior to them. Nah, that's concerning my child. That's my baby. So why would I give information to help you do something to me, help you run one up in me? Nah. Y'all gotta also study these things. I'm gonna do a video soon about an application. Y'all need to understand what the fuck an application is. An application. Hell, this video short, so I just might show it. I might show it myself. I'm gonna show it. I was doing research on it. I'm gonna show y'all in a minute. I'm gonna park this car real quick. I'm pulling up in my driveway. An application is something. Anytime, I know y'all heard a lot of these millionaires, a lot of these well-off people, like Robert Kiyosaki. He's one person I've heard say it because I listened to this his audio book. He has one called Rich Dad Poor Dad. And he was speaking about how people obtain wealth. They can you go out there and make some debt. I didn't understand what the fuck he meant by that. Now I know. I'm gonna show y'all in a second. Okay, I want to show y'all this screenshot. This is from Black's Law Dictionary. I want to say it's the third version, 1968 or something like that. I could be wrong, but it's this from Black's Law Dictionary. I was studying this last night. The application, it says, the definition says, putting to, placing before, preferring a request or petition to or before a person. Let me show y'all. I put that I should have removed that before I screenshot this, but that's what you see, the definition of the application. As you go down, it covers what it means by insurance. This is what I want y'all to see right here. When you say if you doing, say, you put in the application for some type of loan or something, you know. Here we go. What caught my attention right here is really at the bottom right here. I'm going to read the whole thing for right here where it says payments. Appropriation. If you look up appropriation, it's talking about some type of funding. Appropriation of a payment to some particular debt. As you see, that's what it is. That's what they're talking about. They're defining what an application. It's a funding of a payment to some particular debt. That's what an application is. That by definition, when we're talking about making payments, something that where payments are concerned. Then it says, or the determination to which of several demands the general payment made by a debtor to his creditors shall be applied. Now, what caught my attention sure enough last night when I was reading this is the next part right there. Merely an uncommunicated intention or belief on part of debtor as to application of payment to creditor is not such an appropriation as constitutes application by him. So if you never communicated your intentions with this application, that you never probably because we never know that an application actually is the money. We never knew that the application can be used as the payment. Keep in mind, you're giving them the social security number, you're giving them the name, all the information to your estate. You're giving them access to your estate by giving them that information. That's why the Social Security Administration strictly makes it clear we have to protect that number. But we put it on the application, we give it to these people, and we don't know what they're doing with it. We think it's just so they can see that we're worthy of giving a loan to, so that we can be good people that's going to pay them back. Notice you never get no money from these people when you do fill out an application. You never received a check when you do that. Okay? You fill out an application, they run your credit. I'm learning that some people with high credit scores only shows that they're good people. They know that they stand a better chance of getting payments back. They can double dip off these people a hell of a lot easier than someone who won't who won't pay the bills. Keep in mind, the application is what paid for what it is you apply for. If you read the Federal Reserve Act, Section 16, Part 1 and 2, it tells you that the application also, by definition, you see that an application is a payment. Okay, when you look up the word appropriation, let me pause and show y'all that. Black's Law Dictionary, as we see, let me see, show y'all the source, second edition right here, Black's Law Dictionary, appropriation. The act of appropriating or setting apart, prescribing the destination of a thing, designating the use or application of a fund. As you can see, it's talking about some funds right there. See, it has on these, as you see, it takes on different meanings right there. And then now they're talking about in public law, the act by which a legislative department of government designate a particular fund or sets apart a specified portion of a public revenue or of the money in the public treasury to be applied to some general object of government expenditure as civil service lists, etc., or to individual purchase, say, or to some individual purchase or expense. As you see, that's a case law, State versus Moore. Let me see. When money is appropriated, set apart for the purpose of securing the payment of a specific debt or a class of debts or of an individual purchase or object of expense. Say it is said to be specifically appropriated for that purpose. Now you see what I mean by appropriation now. And see, a specific appropriation is an act of the legislature by which a named sum of money has been set apart in the treasury and devoted to the payment of a particular demand. That's Stratton versus Green. And so now you see what the definition of appropriation means. Now we can go back to that same screenshot and show y'all again that same definition about an application. here we go. Back to that again. Appropriation of a payment. The set aside of a payment. Okay? Basically, it's a fund to some particular debt. Now, that makes sense to you once you read the definition of the word appropriation. And you see exactly what it means. The application is actually the application is actually funding that's set aside for the debt. Okay? That's what the application is. So, or the determination to which of several demands a general payment made by a debtor to his creditor shall be applied. Let's see what else we got here. Merely uncommunicated intention or belief on part of debtor as to application of payment to creditor is not such an appropriation, as constitutes application by him. So now you see, anytime we do these applications, we don't even know that the application was actually the funding. That is the funding that's set to the side. And when you look at 12 USC, is this 12 USC? 12 USC 1431. That's where it talks about, the interest. The interest is the responsibility. That's the obligation of the banks. And it also even tells you that the bank's doing the borrowing. So we got to start understanding where, anytime you see an application, when business takes place, most business transactions start with an application. So if you start with the root of the issue, you'll learn that every debt that you think you're a part of, that you are in, every bit of debt that you're participating in, you're actually, there's somebody enriching themselves because you don't know who you are and what you're supposed to be doing. But anyway, I really was talking about not allowing anyone not being so quick to just defend yourself, trying to prove yourself. But I guess it's a 2-in-1 type of video. I just thought I'd kind of throw that out there because it's something I thought I'd make a video about today anyway. But anyway, I'm gonna close with that, y'all. There's something to think about, something to open up your mind and think about. Look up applications, study it out, what it is, what it's about. Understand that you are the creditor, you're the one that's providing the funding from the get-go because you're giving them access to your estate information, your Social Security account, so that they can tap into and then get funding from the Federal Reserve Bank. You can read that in Federal Reserve Act, Part 6 and 16, Part 1 and 2. You read that. You read, look up the responsibilities and duties of banks. The courts are also banks. Look up that definition. They're financial institutions. So anytime the application is being put in for any time you're using your name, there's some funding going on up in there. But anyway, I'm going to get on out of here. Stop being so quick to try to defend yourself when somebody bring you to court. And look at the key elements as to what they're using to get you in court. Look at those types of things when it comes to the applications, the fact that they're administering your estate and you're alive. You got proof on the record that you're not incompetent. You're not in a state of incapacitation, and that's all you need to prove in there. You just filing that on the record kills all that. You ain't got to go in there and do all that damn talking. So most of the time we talk too much and we get ourselves hung by trying to sound like we're the smartest one in the room. Sometimes more is less is more. You say what you need to say and shut the fuck up. That's simple. All right, y'all. Y'all haven't liked and subscribed, y'all. What y'all waiting on? And we'll see y'all in the next video. I'm going to get on out of here. Emerald, signing out.